R. Muhammad is my name. Appearing for the defendant, my lord. May it please, my lord?
Where are you? R. Muhammad.
Yes, my lord. Yes, my lord. My network. I'm trying to do it. Yes, my lord. Yes, my lord.
I've heard you, R. Muhammad. Log
Thank
in
you, my
so
lord.
that I can see your face. Virtual procedures are not different from traditional court sitting. You must ensure to show your faces. Just cannot.
Most guided, my lord. Most guided, my lord.
If you are not ready, any counsel that is ready, call the next case. We'll go back to
ready,
her whenever she is. Because I can't see you on this on the screen. Or am I the only person having challenges?
No, we
my
are
lord,
not seeing her too.
I can see. It's network. I can see you, my lord.
Okay. Mrs. R. Muhammad, please, can you mute yourself? On any other person joining these proceedings? Judgment. The two defendants in this case are Mustafa Bukar, first defendant, and Ibrahim Oje, second defendant. The defendants are standing trial before this honorable court on a 3-count charge, number FH3GS DM 2021, dated 4th November 2021 and filed 8th November 2021. The defendants were arraigned before this court on allegations bordering on conspiracy, dealings in, buying, and sale of currency notes, knowing fully to be fake and offer same for sale by the first defendant, inducing the second defendant to buy the say 387 counterfeit notes of $100, an offense contrary to the provisions of the Counterfeit Currency Special Provisions Act, Cap 35 laws of the Federation of Nigeria 2004. The charge reads, there are 3 counts. The first one is due Mustafa Bukar and Ibrahim Oje on or about 8th October 2021 at Gashuabadi local government area, Yobe State, which is within the jurisdiction of this honorable court. You conspired and dealt in, buy, and sell US 100 notes of 387 pieces. You, Mustafa Bukar, induced Ibrahim Haruna to buy 387 counterfeit notes of $100, knowing fully to be fake and offered same for sale. You thereby committed an offense punishable under Section 4(1) of the Counterfeit Currency Special Provisions Act, Laws of the Federation 2004. Second count that you, Mustafa Bukar, on or about 8th October 2021 at Gashuabadi local government, Yobe State, which is within the jurisdiction of this honorable court, you were found in possession of 387 counterfeit notes of US $100, knowing fully to be fake and offer same for sale. you thereby committed an offense punishable under Section 4 sub 2 and 5B of the Counterfeit Currency Special Provisions Act, Laws of the Federation of Nigeria, 2004. 3, count 3, that you, Mustafa Bukar, on or about the 8th day of October 2021 at Gashua Badi Local Government Area, Yobe State, which is within the jurisdiction of this honorable court, you falsely makes and counterfeit notes of US $100 of 387 pieces, knowing fully to be fake, and offer same for sale. You therefore committed an offense punishable under Section 1 sub 3 and 4 sub 2 of the Counterfeit Currency Special Provisions Act, Laws of the Federation of Nigeria, 2004. The defendants were arraigned before this court on the 24th day of November 2021, wherein both pleaded not guilty to the charges and were therefore remanded at the Potiskum Correctional Center. Of the 3 counts, only count 1 of the charge is relevant to the second defendant. The rest of the counts 2 and 3 affect 1, 2, and 3 affect the fourth defendant. At the trial, the prosecution called 4 witnesses and tendered 11 exhibits, both real and documentary exhibits, in an attempt to prove the allegation against the first and second defendants. I've summarized the case of the prosecution, but I'll not read it out. Eventually, in the body of the judgment, it will be, I'll read it out. Now, in criminal trials such as this one, it is the duty of the prosecution to establish the guilt of the defendants of the offense charged beyond reasonable doubt in order to secure a conviction. See Section 135, 1 and 2 of the Evidence Act. On the burden of proof and standard of proof in criminal cases, the law is settled beyond citing of any authority that the burden is constantly on the prosecution. It does not shift, and proof is beyond reasonable doubt. See State versus Olobolo, 2017, LPLR 48405, Supreme Court, where it was held in any criminal offense or offenses such as the respondent and others has been charged with, the standard remains undiluted as prescribed by our law and orchestrated within the provisions of Section 135 of the Evidence Act 2011, which I shall quote thus. If the commission of a crime by a party to any proceeding is directly in issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. The burden of proving that any person has been guilty of a crime or wrongful act is subject to the provisions of Sections 139 of this Act on the person who asserted whether the commission of such act is or is not direct in issue in the action. Sub 3, if the prosecution proves the commission of a crime beyond reasonable doubt, the burden of proving reasonable doubt is shifted on to the accused. That prescription of being proved beyond reasonable doubt, and the Court of Appeal and Supreme Court have again and again stated the implication or meaning thereof. And I shall refer to a few of them for clarity. See Ingbang versus State 2013, All Federation Weekly Law Report. Adekoya versus State 2013, All Federation Weekly Law Report. In Ingbang versus State, Supra, the Court of Appeal held as follows, that there can be no doubt in criminal cases, such as in the instant case, the onus is on the prosecution to establish the guilt of the accused person beyond reasonable doubt, as settled law implying that unless the prosecution has discharged this onus, he is not entitled to succeed. See Mandelas versus Carberries Limited versus Inspector General of Police, 1958, 3 FSC 20. This settled principle of law agrees with the proposition of the law that one who asserts a disputed fact must prove it. It is also settled that there's no onus on the defendant in criminal cases to establish his innocence. See Ogbewe versus Inspector General of Police, 1958. This burden on the prosecution does not shift as it rests squarely on the prosecution throughout. Therefore, the presumption of innocence is a hallowed principle lying at the heart of criminal law. It ensures that until the defendant's guilt is proved beyond reasonable doubt, he or she is innocent. This is essential in commitment to fairness and justice. It needs to be added that the burden of proof does not shift. Once there's the slightest doubt in the mind of the court, such doubt must be resolved in favor of the defendant, who should subsequently be acquitted by the trial court. See Alonge versus IGP, etc. The proof of guilt of an accused person by the prosecution must be done through any of the underlisted methods, namely A, the voluntary confession of the accused person, B, through direct, credible, and reliable eyewitnesses or victims of the offense account, depending on the circumstances of the offense, and C, through circumstantial evidence pointing or focusing on the guilt of the accused person, that he was the one or one of the persons who committed the offense or offenses charged, and by no other person but him. See Adio versus State, 1986, 2 NWLR, Emeka versus State, 2001, Ebonome versus State, 1993, 7 NWLR. In Mohammed Latif versus the State, 2018, LPLR, the Court of Appeal, Pa Mohammed Anbi Usid Anjuma JCA, on whether proof beyond reasonable doubt means proof beyond all iota of doubt and how it is attained, held that it is tried in law that the requirement that the prosecution must prove the commission of an offense beyond reasonable doubt does not mean beyond all iota of doubt. All that is required is proof that will fit the accused person with the commission of the offense. Such proof must be by compelling and conclusive evidence. See Adewale Joseph versus State, 2011, 6 SCNJ, Rabi Ismail versus State, 2011, 7 SCNJ, Adebayo versus State, 2008, State versus Akpabio, 1993, 4 NWLR, etc. The defendants in this case are jointly charged under count 1, and the charge, I've read the charge earlier on, which are dealing in counterfeit currency, which comes under the provision of sections 4(1), which reads, section 4(1) of the Counterfeit Currency Special Provisions Act, supra, any person who deals in, buys or sells or exposes or offers for sale or induces any other person to buy or sell any counterfeit banknote or current coin, knowing the same to be counterfeit banknote or current coin, is guilty of an offense under this act, and on conviction thereof shall be sentenced to life imprisonment. Now, in establishing possession, the first ingredient of the offense, the prosecution called PW1 the arresting officer. PW2 is the investigating officer. PW3 is forensic expert from the Central Bank of Nigeria. And PW4 is the exhibit officer with the CID Damaturu, Yobe State. The evidence of the PW1 already reviewed above but summarized below. PW1 is Inspector Adzahan Matthew, a 43-year-old police officer attached to the Criminal Investigation Department, CID in Damaturu, testified regarding a case involving criminal conspiracy, breach of trust, cheating, and misappropriation. The case reported on 8th, 10th, and 18th October 2021 involved two defendants, Mustafa Bukar, first defendant, and Ibrahim Haruna, also known as Datti, second defendant. Initial investigations at the area command in Gashua, the case was later transferred to the state CID in the state capital. During earlier investigations, the second defendant implicated the first defendant in a conspiracy with one Alhaji Abba and Alhaji Adamu to produce counterfeit US currency, leading to the arrest of the first defendant. Inspector Matthew, part of the investigating team at the state CID, recorded confessional statements from both defendants. The statements were made in Hausa, translated into English, and read back to the defendants, who confirmed their accuracy. These statements were signed in the presence of superior officers and relatives of the defendants. PW1 emphasized that the confessions were made freely, without coercion or inducement, and were duly endorsed by ASP Martina Bello. The investigation involved a visit to the crime scene in Gashua, where PW1 registered 307 pieces of counterfeit US currency as evidence. The exhibit was packaged and sent to the Central Bank of Nigeria for analysis. The investigation also uncovered various foreign currencies, including Dubai dirhams and Bangladesh taka. Photographs were taken of the first defendant with the counterfeit currency. Despite completing the investigation, the result of the currency analysis were then still pending. PW1 testified further that the first defendant was in possession of the counterfeit currency revealed by the second defendant. The second defendant claimed the first defendant frequently visited his shop to collect 360,000 naira in Nigerian currency, later producing the counterfeit US dollars. During investigation, the first defendant disclosed trips to Kano, Maiduguri, Adamawa, where he and others obtained materials to print fake currency. A dispute arose when the second defendant failed to provide additional funds for the operation, leading to allegations of misappropriation. The case highlighted the first defendant's central role in producing the counterfeit currency, with the second defendant acting as a co-conspirator. The investigation linked both defendants to attempts at counterfeiting and financial misconduct, ultimately leading to their arrest. PW1 concluded that the statements and evidence gathered were obtained lawfully and without any form of duress. From the above testimonies, the first ingredient of possession by the defendants has been established. This honorable court holds that the evidence led by the prosecution is unshaken. I so hold. On the second ingredient, whether the recovered currency notes were genuine or counterfeit, PW3 Ahmed Usman is a 48-year-old public servant working with the Central Bank of Nigeria, with the Currency Operations Department, Abuja, which was then with 8 years in service. The PW3 testified that the police brought some notes suspected to be counterfeit, and it was received and then forwarded to the Currency Operations Department, Abuja, which was then forwarded to the Nigerian Security Printing and Minting for confirmation, which Nigerian Security Minting verified the genuineness of all currency notes, called adjudication, and the result after verification was received through correspondence confirming that the 387 pieces of $100 are found to be counterfeit. That after receiving the letter confirming that the currency was fake, the result was forwarded to the Nigerian police, Damaturu, and attached forging letters from the Nigerian Security and Minting press confirming the status of the currency, another letter from the Director of Currency Operations Department, and another letter again from the Branch Controller, Central Bank of Nigeria, Damaturu. From the above testimony, which highlighted the processes used from the police to the Central Bank of Nigeria and to Nigerian security and minting press using forensic security documents examination, which method was said to have confirmed the status of the currency, said to have been found in possession of the first defendant to be counterfeit through correspondences tendered as exhibits. This honorable court holds that the evidence led in this respect has not been challenged. See Magaji versus Nigerian Army, 2008, NWLR. I so hold. On the third ingredient, which is the mens rea or knowledge of the offense, can be confirmed from the extrajudicial statements of both defendants recorded in the presence of their relatives. The first defendant, I'll read out verbatim what the extrajudicial statement of both defendants. Starting with the first defendant, he wrote, "I was born and brought up in Mecca, Saudi Arabia. My parents are Abubakar Kolo and Mariam Osman. I did not attend Western education. I have knowledge on Islamic education. I'm married with one wife named Fatima Mustafa, and the marriage is blessed with one surviving male child. I am an Islamic scholar, Al-Majri. I knew the suspect, Ibrahim Haruna, as a businessman. He's also known as Datti. And his shop is located beside Al-Heri Supermarket, Gashua, in Badia local government area. Prior to this ugly incident, the said Ibrahim Haruna, aka Datti, led on several occasions went to me seeking for prayers in order to make his business go higher, which I've been praying for the success of his business. He used to give me some money in appreciation to the prayers alone, which amounted to 20,000 naira. I could also remember recently, he requested for more and higher prayers. During this period, I invited one Madam Abba and Madam Adabu of various addresses now at large, who were introduced to me by one Madam Goni Mustafa of Yola Town in Adamawa State as prayer warriors for the prayers. And on the process, Ibrahim Haruna aka Datti brought the sum of 620,000 naira for the purchase of some chemical. Later, 42,000 naira was used again as demanded by Madam Abba, Madam Adamu, and myself. All these monies were used and printed some currency suspected to be counterfeit. I'm not aware of the subsequent discussion and transaction between Ibrahim Haruna aka Datti and the two suspects at large. I've been into the system for about 4 months ago and had traveled out to places like Yola and Maiduguri towns together with Ibrahim Haruna aka Datti severally for buying of items and materials used for the printing of the suspected counterfeit. The suspected counterfeit recovered from me by the police at the Area Command Office Gashua includes 387 notes of $100 US, one note of 5 dirhams of UAE currency, one note of 5 Taka Bangladesh currency, one note of 250 dinar, and one note of 1,000 dinar Iraq currency. All these suspected counterfeit were recovered in my possession during the course of investigation. I don't have any bank account. I used one Madam Musa's account and collected 150,000 from Ibrahim. That's the second defendant. Now, I'll read on the second defendant's statement, Ibrahim Haruna, that I was born and brought up in Katuzu area, Gashobadi local government area. My parents are Haruna Danlami and Aisha Usman. I attended Ramat Primary School Nguru between 1998 and 2004. I also attended Government Day Secondary School Gashua between 2006 and 2012, where I obtained both first school level certificate and SSCE certificate respectively. I'm married with one wife, and the marriage is yet to be blessed. I'm a based businessman who used to buy and sell all types of TVs, tricycle, TVS tricycles, keke napep. And my business shop is located behind Alheri Supermarket, Gashua, by the local government area, and have been into business for about 4 years now, 4 years ago. My uncle, one Alhaji Bala Musa of Alheri Supermarket, Gashua, introduced me to one Awalu Ubangida of Damaturu town, Yobe State, a dealer and distributor of tricycles, and have been supplying tricycles to me for sale. And I only receive all in cash after sales. For about 2 months ago, I was supplied with 22 units of TVS tricycles, all valued 20,680,000. He also supplied spare parts, all valued 2,183,240. Limited the sound process disturbing proceedings. Remitted the sum of 5,625,000, remaining the cash sum of 15,055,000, which totals sum 17,283,240 naira yet to be remitted. I've sold all the tricycles, but the money got wasted through fraudulent means. One Mustafa Bukar of Laon Fannami area, Gashua, in Badi local government area, conspired with one Madam Abba and Madam Adamu, both men of various addresses, who claimed to be money doublers who printed fake currency, suspected to be dollars, and collected all my money through fraudulent means. That is, collected all the real naira, real currency. The following persons gave me their money for the supply of the tricycles, which is yet to be supplied. These Bada Masi Bello, 665,000 naira, Usman Umar, 750,000, Hamza Ismail, 930,000, Ismail Yusuf, 725,000, Bashir Mukhtar, 935,000, Ahmed Mukhtar, 200,000, Yusuf Isa, 600,000, and Malam Guru, 400,000. I also transfer all the money I was defrauded through account number 01023475150. Account name is Habibu Hambali Access Bank, PLC. Other accounts named, but have forgotten the account numbers: the Umar Abubakar GTB PLC, Inusa Mohammed UBA PLC, and my account number 3123494813, First Bank PLC, bearing Haruna Ibrahim. Now, this is the end of the statement. Now, the above extrajudicial statement of the defendant was further corroborated by the testimony of PW2 Sergeant Abba Ibrahim, a 38-year-old police officer attached to CID Damaturu, who testified about his involvement in the investigation of a case reported on October 8, 2021. The case brought by Bala Musa of Gashua Town involved allegations against Ibrahim Haruna, that's the second defendant, and Mustafa Bukar, first defendant, along with 5 others now at large. The second defendant was entrusted in 2018 with 20 tricycles valued at 19 million naira by Alhaji Awal Hassan Wangari, but sold him and in conspiracy with the first defendant used the proceeds to produce counterfeit US currency. The first defendant further shielded the co-conspirators, including Adamu Bauchi, Mustafa Yola, and others. During a search of the first defendant residence, PW2 and his team recovered 387 suspected counterfeit 100 US notes, 4 mobile phones, and foreign currencies, including Afghan dinars and Dubai dirhams. Both defendants were taken into custody, and preliminary investigations were conducted at the Area Command Gashua. PW2 confirmed that after initial findings, the case, along with the defendants and exhibits, were transferred to the state CID in Damaturu for further investigation. The counterfeit notes were later sent to the Central Bank of Nigeria for forensic analysis, with PW2 testifying that all evidence and suspects were handed over to the CID as part of the ongoing inquiry. It stated that the investigation at the area command level established a connection between the defendants and the counterfeit operation, leading to their eventual prosecution. This honorable court inferred that both defendants had mens rea, that's knowledge from the surrounding circumstances, as outlined above. See Akpa versus State 2008, 14 NWLR, Shazali versus State 1988, Owakwigenya versus State 2005, 9 WLR, etc. Since the currency confirmed to have been found with the first defendant was twice what the law provided, and the defendant did not prove the contrary, then he has knowledge. The first defendant in examination in chief testified that the counterfeit currency was given to him by a neighbor that traveled. Yet, when challenged through cross-examination, the first defendant could not describe how the neighbor looks like. This on whether tall, short, fat, he couldn't describe him. This honorable court, having discharged its duty of evaluating evidence, hold that the first defendant has knowledge of what was in his concrete possession, thereby confirming the third ingredient I so hold. From the above analysis through the testimonies of all the witnesses before the court, as well as all the exhibits tendered, all the evidence points to the fact that it is obvious that the prosecution has disclosed a prima facie case against the defendant, which has not been contradicted and has therefore succeeded in discharging the onus of proof placed on it beyond reasonable doubt. Accordingly, this honorable court, having evaluated the evidence before it and having arrived at its findings, hereby holds that the prosecution have proved its case beyond reasonable doubt. The first and second defendant, Mustafa Bukar and Ibrahim Haruna, are hereby convicted as charged. I shall listen to their advocates before pronouncing on their sentence. Can you,
My lord.
Can you interpret to them to the best of your ability?
Yes, my lord. Mustafa Bukar da Ibrahim Haruna, kamar yadda yau kotu ta gama kammala dukkan jawabai da ta samu da kuma sakamako na bincike akan wannan kuɗin jabu da ake zargi akan ku, to kotu ta tabbatar da duka kowanne ya tabbata lalle kun kasance masu laifi, akan haka za ta muku hukunci. As court, please, madam.
Any record of previous conviction? Prosecuting counsel? Prosecuting counsel from the Aegis chamber? The prosecuting counsel from the Aegis chamber? Can somebody find out what is happening?
Muted. Prosecuting counsel, Musa, you are muted. Please unmute yourself.
Prosecuting counsel from the AG's chamber, Minister of Justice, unmute your device. Can you see him on the screen?
My lord.
Yes, unmuted himself.
Counsel, we can't hear you. Can you hear counsel at your own end?
No, my lord.
Counsel, can you increase the volume of your device? The volume of your device is probably low because we can't hear you. Can you speak up? Can you bring your device closer and talk to your device? Maybe we can hear you because I can't hear you. Any record of previous conviction? Counsel, can you hear the court? I still cannot hear counsel. I do not know where the problem is. He's unmuted yet I cannot hear him. Mr. Salisu at the Correctional Center.
Yes, my lord.
You ask the first defendant if he has anything to say to the court. Does he have anything to say?
Alkali ta ce a tambaye ka akwai wani abin da za ka gaya a kotu ne? To ka daga muryanka sosai.
Ina roƙon wannan kotu.
Daga muryanka sosai.
Ina roƙon wannan kotu mai alfarma mai sassauci. Ni almajiri ne. Ina cikin karatu wannan jarrabawa ta same ni.
Yes.
Ko da kasancewa jarrabawa wannan da ya faru karatu na ya koma baya.
Yes.
Karatu na ya koma baya, abinda na samu ma duk yana kokarin lalacewa. Kuma na kasance ina cikin kokarin neman haɗa karatu. Har Allah ya kawo wannan tsautsayi. Ba zan ƙara wannan makamancin irin wannan laifi ko da kusantansa. Na ɗau darasi daga wannan gida, insha Allahu Rabbi, abu da irin makamanci wannan ko da mai yi ba zai kusance ni. Sa'an nan, na kasance ina koyarwa, ina da almajirai ƙwaya 43.
Yes.
A cikinsu kuma akwai wanda suka kasance marayu. Wani bashi da mahaifiya, wani bashi da mahaifi.
Yes.
Sa'an nan jinyace-jinyacen su ya rataya a wuyana. Ni kaina maraya ne. Ina da mahaifiya guda ɗaya. Ta kasance majinyaciya ce kuma ta manyanta ta tsufa. A halin yanzu yadda take ciki ma tana buƙatar agajin gaggawa. Sannan ina da iyali. Ina da 'ya'ya mata su 3. Mai ɗakina ta kasance mareniya ce. Dama amana aka ɗauka a gaban. Ba ta da mahaifi, ba ta da mahaifiya.
What do you want the court to do for you?
Me kake so kotu ta maka?
Ina roƙon wannan kotu da ta yi duba yanayin ciki da nake cikinsa da ta mun sassauci, hukunci mafi sauƙi da ta sassauta mun in koma karatuna. Karatuna ya ci baya. Ina roƙon wannan kotu da ta yi dubayya ta sassauta mun.
The second convict, does he have anything to say?
Akwai wani abu da za ka iya gaya a kotu?
Na roƙon wannan kotu mai alfarma mai girma, wannan laifi da muka aikata ma'aikata bisa kuskure bisa rahin sani, sannan kuma wannan jarabawa da ta same mu mun ɗauki darussa da yawa a cikin wannan gida. Insha Allah ba za mu sake aikata laifi makamancin wannan ba. Sannan kuma na kasance maraya, ina da mahaifiya. Wanda Allah ne ya tantance ni ne kuma ba cikin yaranta. Ni ne mai cin shanta sauran 'yan uwana.
Is that it?
Sannan kuma yana da iyali. Sakamakon wannan jarabawa da shiga karatun ƙanina ya tsaya.
Mr. Salisu,
Yes, madam.
can you interpret to them the charges against them? Some are life imprisonment, some are 21 years in prison.
That's good place, madam.
The charges against them, because there are 3 different charges. So some of the charges are life imprisonment and some 21 years.
That's good place, madam. Tuhumar da ake muku a cikinsu akwai wanda hukuncinta rayuwar dindindin ne ta gidan fursuna. Akwai wanda kuma hukuncinsa shekara 21 ne. a zaman gidan fursuna. Alkali ta ce a gaya muku. Escort, please.
The council, do you have any submission wanted to make? Or should I go on to the sentence?
Yes, my lord. I do, my lord. My
Yes,
lord,
go ahead then.
Since the convict has shown remoteness and deeply regret for their action, my lord, and being considered that they have family and they are the breadwinner of their families, my lord, we urge this honorable court of justice, my lord, to temper justice with mercy in sentencing the convicts, my lord. Thank you, my lord. So much praise.
Lauya mai kare ku ita ma ta ce dubi da irin wannan roƙo da kotu ita ma tana ƙara roƙon kotu a dubi da iyaye da ɗawainiya da kuke da iyalai da waye kotu ta sassauta wajen yi muku hukunci ita ma tana roƙa kotu.
Sentence.
Please, my lord.
Having listened to the plea mitigation made by the convicts and this court having taken all that into account, the person sentenced on the convicts, I take into consideration that they are both first-time offenders before this honorable court. Consequent upon my findings above, the defendant having been found guilty to all the 3-count charge, I therefore find the first convict, Mustafa Bukar, guilty of the offenses as charged in count 1 and is hereby sentenced to 7 years imprisonment, being the minimum sentence the court can impose. Both count 2 and 3, the convict, Mustafa Bukar, is sentenced to 7 years imprisonment, each.
Escort, please, ma'am.
Which is to run concurrently.
Escort, please, my lord.
For the second defendant, Ibrahim Haruna, who has been found guilty to only count 1 charge against him, is sentenced to 5 years imprisonment. The sentence for both of them shall be deemed to have commenced from the 24th November 2021, when they were apprehended and arraigned before this honorable court, pursuant to the provisions of the Counterfeit Currency Act, SUPRA. This is to serve as a punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. This shall be the court sentence of the convicts, which sentence is no doubt very light. It was deliberately made so in order to encourage the convicts to quickly retrace their steps and return to the society as changed persons. Meanwhile, this honorable court, anyway, you can interpret before I continue.
As court, please, my lord. Mustapha Bukar, akwai tuhuma uku da aka same ka aka tabbatar da kai mai laifi ne. Saboda haka kotu, tuhuma ta farko kotu ta ɗaure ka shekara 7. Tuhuma ta biyu da ta uku ma shekara 7. Amma dukansu za ka yi, duka ɗaya yana shiga ɗaya ne, gaba ɗayansu. Mustapha Bukar. Kai kuma Ibrahim Haruna, kai kuma shekara 5 ne aka ɗaure ka. Shi ne abin da kotu ta yi. Sannan wannan shi ne hukuncin da kotu ta yi, kuma kotu ta ce hukuncin yana cike da sassauci saboda ainihin hukuncin da aka ce a yi, na fi gaya muku da zo an ce ko rayuwar imprisonment ko kuma ko life imprisonment ko kuma shekara 21. To amma bisa ga roƙo da kuma dubi da yadda kotu ta duba da lauya ya roƙa muku kuma ku roƙi kotu, shine kotu ta yi wannan hukunci ta sassauta muku. Ta ce hukunci yana cike da sassauci sosai sosai. As court, please, my lord.
For them to return to society as changed persons.
As court, please, my lord. Kuma ta ce in kuka gama ku koma cikin al'umma sai zama kun gyara, ba za ku ƙara makamancin wannan laifin ba.
Meanwhile, the second convict, how many years did you say?
5 years, my lord.
Okay, so okay. Meanwhile, this honorable court hereby orders as follows. The seized exhibits recovered from the defendants, and after visiting the scene, being the envelope with the serial number HBO 3834116P with 75 pieces with serial number 001/073, marked as Mustapha Bukar 2A. The envelope with serial number HB 43831012P with 155 pieces of counterfeit US $100 bills with serial number 001-073, marked as Mustapha Bukar 2B, and the envelope with serial number BB219970414C with 175 pieces with serial number 001-073, marked as Mustapha Bukar 2C, respectively, shall be returned to have been confiscated and shall be forfeited to the federal government of Nigeria through the Central Bank of Nigeria, pursuant to the provisions of the law, which provides that any court of law may order the forfeiture of such to which the offense relates, and such shall be disposed of in accordance with the Central Bank Act. For the two Samsung phones and one Bravo closed brand phone, already admitted into evidence and marked as Mustapha Bukar 4A and 4B, while the Bravo phone marked as Mustapha Bukar 4C is to be given back to their families to be kept in trust for the defendant until they return back to after they have finished their sentence.
As court, please, my lord. Kuma sannan kotu ta ce hukuncin zaman ku na gidan fursuna zai fara daga ranar da aka kama ku, shi ran 21 ga watan 11 shekara ta 2021, kamar yadda kotu ta faɗa.
Their phones to be returned back to their families, and they have the convicts have 90 days within which to appeal both the conviction and sentence if they are not satisfied with same.
Tace kuma ku koma cikin iyalanku bayan kun gama cikin aminci, kuma ku zamo kun gyara da aikata makamanci irin wannan. Sannan kuma in hukuncin bai game ku ba ma za ku iya ɗaukaka ƙara daga nan zuwa wasu. Wayoyinku kuma da aka karɓa za a bara iyalanku bayan kun gama, za ku je ku karɓi su. A ba wata da an faɗa.
Allah saka. Allah kare ku.
Thank you. Thank you. Call the next case, please.
And judgment, my lord. We are much grateful.
Welcome. Call the next case, please.
As the court pleases. Charge number FPSC/DM/CR/40/2024 between the Federal Republic of Nigeria and Nasir Lawan.
Nasir Lawan. Yes, my lord, the defendant is here at the correction center, please.
Any representation? Representation.
My lord, to profound humility, my lord, I humbly and respectfully for the complaint.
Please, can you announce appearance again? I didn't get that.
With profound humility and respect, my lord, J. Abdul Qadir is my name, my lord. I humbly and respectfully announce my appearance for the complainant, my lord.
Okay, J. Abdul Qadir, where are you?
My lord, I'm sitting in the office, my lord.
I've not seen you on the screen.
My lord, I have joined the virtual sitting, my lord. Maybe the network is not strong, my lord, but I'm seeing you, my lord.
Registry, can you see J. Abdul Qadir Esquire?
No, my lord.
No, my lord.
Well, I'm live, my lord. I'm in the forum, my lord.
I can see the registry of court. I can see others
I've
that
seen
have
him too, my lord.
joined. I can see others. Those are the.
J. Abdul Qadir, which device are you using?
I'm using Techno phone, my lord. BD4J.
I saw you there, but you are not visible.
Yes. I can see. The network is a problem, my lord. But I've been busy. Before I can see my picture, but now I myself, I cannot even see my picture on the screen. Well, now I can see the registry. The network is maybe fluctuating over here.
Maybe you have not on the video on your device.
My lord, I can see you. The video is on, my lord.
His video is on, my lord. It's a network problem. Okay, he is back now.
Okay, I can see you now.
Okay, my lord. As the court pleases, my lord.
The convict Nasir Lawan was arraigned before this court on a one-count charge. The convict, having confessed to unlawfully, with intent to destroy, damage an electricity transformer, property of Yola Electricity Distribution Company, by tampering and removal of pieces of electricity armored cable from an electricity transformer at Government Girls Unity College, Damaturu, and thereby committed an offense contrary and punishable under Section 1B of the Miscellaneous Offences Act, Cap M17, Laws of the Federation of Nigeria, 2004. When the convict was brought to court, he pleaded guilty when arraigned, and the prosecuting counsel applied for a summary trial, to which the court obliged, and the sentencing of the convict adjourned to today. In passing sentence on the convict, the court is required, especially in such cases involving the malicious and deliberate destruction of public property provided for the common good of the citizenry or society, to take into consideration the nature of the extent of vandalism involved, perpetuated by this convict in this case. You, Nasirullah, not only tampered and removed vital and extremely expensive components of electricity armored cable from an electricity transformer property of Yola Electricity Distribution Company without lawful justification, and you were on the verge of selling the vandalized, damaged transformer cables when arrested. This honorable court must consider the amount of hardship the consumers of electricity being the people of Damaturu, and by extension, the whole of Yobe State, endured and are still enduring because of the activities of such miscreants, thereby sabotaging the Yola Electricity Distribution Company as well as the government. The convict had deadened his conscience and plunged the state or the secondary school into darkness and into hardship and suffering. A lot of people, because of such miscreants, suffer because of the damage, colossal damage caused by your horrendous acts. Businesses suffer, destroyed by the recklessness of such people as the convicts. Patients in the hospital do suffer, etc. Don't you have any conscience? Do you derive pleasure on the suffering of millions of people that rely on electricity on day-to-day basis for their livelihood? The deliberate destruction of public property endangers your own lives, to which you are paid pittance. Now you have destroyed the transformer, you have taken the damaged cable and want to sell it for nothing, for zero amount compared to the actual amount of the cable. Can you not look for other means of sustenance rather than this job of destruction of commonly shared facilities? Can't you find ways of earning legitimate money? This honorable court will portion to Section 122 Evidence Act 2011, read out a portion of the court's holdings in a similar case of Federal Republic of Nigeria versus Shamsuddin. Let me, Madam Salisu, can you interpret to the best of your ability?
Yes, my lord. Yau da ake gabatar da ainihin hukunci na wannan shari'ar take gaban kotu, inda kotu take jawabai kamar haka. Wannan transformer da kaje ka bata kake daukan wani kebul da ake kiransa amo kebul, yana sa mutane cikin mummunar rayuwa saboda duk rayuwa yanzu ta ta'allaka ne akan wutan nefa. Idan hakan ka aikata laifi kamar haka, yanzu dai kotu tana ta kan jawabai, sai ta ce a gaya ma dai a kaji abubuwan da take faɗa. As court, please, my lord.
In that case, Federal Republic of Nigeria versus Shamsuddin, I held that the activities of such convicts and others like him have brought so much hardship on the citizenry and the government, almost paralyzing activities. This is akin to sabotage, which is why this honorable court does not believe that the boys were acting on their own. There are others enticing them with money or some other material things. The question that needs to be asked is, who are the sponsors of these boys? All security agencies must wake up and conduct discreet and thorough investigation to find out how these young men scavenge iron and steel scraps. To whom are they selling the scraps? It has been sold to blacksmiths to melt the wires, or sold to unscrupulous businessmen that deals with electronic items, or what? By the high number of such vandalism throughout Yobe State, it has been turned into a commercial enterprise that has turned into a vicious circle. The convicts, by stealing cables from transformers, are the ones at the beginning of the chain. And where does the chain follow and eventually stop? The above questions can only be answered through discrete investigations on all encompassing sister security agencies collaborating together so that those involved can be fished out and whoever is found to be culpable to be prosecuted. There is need to checkmate the daring and ravenous activities of such people as the sponsors of the convicts in order to salvage Yobe State and our nation from the activities of these unscrupulous, unpatriotic, and merciless people from masquerading as businessmen or scavengers. The prevalence, nuisance, and destructive social and adverse economic consequences of such people as the convicts can only be imagined. The health and rights of the citizenry as well as the economy of a nation is what is at stake. Therefore, security agencies must seek more vigorous approaches to deter and checkmate the daring activities of the sponsors of these young men. The sponsors are also putting the lives of these young men at great risk to go and kill themselves by tampering with electrical transformers. That was what I read out in my previous judgment in another case. Now I'll continue. This person here is not a young person per se. He's young at 27 years, but he is of an age where he knows what he's doing, unlike the former case I just mentioned, where they were young boys below the age of 18. Now, the provision of the law under which the defendant is brought provides any person who unlawfully or with intent to destroy or damage any public property, removes, defaces, or damages any public property shall be guilty of an offense and liable on conviction if the property in question is a railway line, electric power line, telephone line, or a demarcation line on a public highway, and the property is damaged or rendered dangerous, impossible, or non-functional to imprisonment for a term not exceeding 21 years without the option of fine. This instant case was reported by a member of the Scrap Association, who in turn with their chairman reported to the Civil Defense, who quickly mobilized, investigated, and brought the suspects, as the defendant and now convict, to court. This court would like to extend its appreciation to members of the public who are raising awareness on such vandalization. I particularly thank the commandant of Nigeria Civil Defense Corps and his staff of going above and beyond the call of duty in trying to keep the peace in Yobe State. Consequently, having regard to the considerations which are analyzed are factors which ought to inform the sentence which this court will pass. Can you interpret to an extent, Malam Salisu?
Yes, Malam. Kotu ta ce, wannan ayin laifin da ka aikata, lalle laifi ne wanda hukuncinsa yana baya ƙasa da shekara 21. Kuma sannan dama duk wani laifi wanda zai aikata laifi har da irin naku na masu bata transformer ya sa mutane a cikin matsalar rayuwa, to lalle dama akwai hukunci mai ƙarfi wanda doka ta tanada kamar yadda yanzu kotu take faɗa. Kuma sannan sai tana godiya a hukumar masu harkar ajakuta da kuma ciyaman ɗin su kansu masu harkar scrap ɗin da kuma su hukuma na ta civil defense inda suka yi hoɓɓasa wajen gurbanar da kai a gaban kotu da wuri kamar yadda yanzu a kotun take sanarwa. As court, please, madam.
Thank you, Mr. Salisu. Consequently, having regard to the considerations which are analyzed are factors which ought to inform the sentence which this court will pass. In the final analysis, I hereby sentence you, Nasiru Lawal, to 8 years imprisonment for the counts, for the offenses you have been convicted of, to to commence from date of arraignment. This is to serve as punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime and or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject you are enjoined to stay true to your words and lead an exemplary life after serving your sentence. The exhibit shall be returned to the Office of NSCDC, that's the Civil Defense, which in turn is to return same to the Yola Electricity Distribution Company. The convict has about 90 days within which to appeal both the conviction and sentence if he is not satisfied with same.
As the court pleases.
Nasiru, yin bisa ga kotu ta tabbatar da hukunci akan laifin da aka same ka da shi kuma aka tabbatar. Kotu ta ɗaya ka shekara 8 a zaman gidan yari, amma za ka fara daga lissafi daga ranar da aka kawo ka. Sannan ta ce, wannan kamar da gaya mata hukuncin ainihi baya ƙasa da shekara 21. Kuma kotu ta yi la'akari da dubi da hukuncin da ta maka wannan hukunci shine shekara ta daga ranar da aka kama, shine wannan abin da kotu ta yanke mu. Kuma ta ce in ka hukuncin da ta kana da yanci daga nan zuwa kwana 90 ka ƙara zuwa kotun gaba. Kotu ta duba ta.
Thank you, Mr. Salisu.
Thank you.
Okay.
We thank a lot for a well-considered judgment, madam.
Thank you, counsel.
Thank you, madam.
Please, can you call the next case?
Charge number FSC/DM/CR/46/2024 between the Federal Republic of Nigeria and Saleh Ali.
Yes, my Lord, the defendant is present here at the correction center. And he speaks Hausa, my Lord.
Representation. Counsel is muted. I can't hear you. I still cannot, the same problem as earlier. Your device has a problem. I can't seem to hear a word. Counsel from the Aegis Chamber, can you introduce yourself? Counsel, we can't hear you, and if I can't hear you, there's no way the matter can continue, because this case is formation and you're the prosecuting counsel. Maybe you look for another device. I can hear everybody else, but I cannot hear counsel, and I do not know where the problem lies. Any defense counsel? We'll call the next case before try and see how you can rectify the problem by maybe using another device. You can use your own hotspot, maybe. Can you hear me, counsel? So you maybe try using somebody else's device by tapping onto your own hotspot. Maybe it will work. Meanwhile, Registry of Court, please call the next case.
Court please. Charge number FSC/DM/CR/55/2024 between the Federal Republic of Nigeria and Aliyu Alhaji Aliyu. Aliyu Alhaji Aliyu. Yes, my lord. The defendant is in court and he speaks Hausa.
Representation.
With profound respect and much honor, my lord. My name is Usman Bamada. Appearing with me is my learned friend, Mr. Ibrahim Muhammad. My lord, we humbly announce our appearance for the complainant. My lord, the matter is fixed to the formation. Subject to my lord's convenience, we are ready to proceed.
I think there are two devices that are, or the other device should be muted, please. Maybe the one with the defendant. No counsel, no defense counsel. Yes.
May it please this honorable court, my lord, MB Ngohi, my humble and respective appearance is for the defendant, my lord.
My lord, the matter is fixed to the formation and subject to my lord's convenience and that of my learned friend, we are ready to proceed.
We are equally ready, my lord.
Go ahead then.
My lord, the complainant have filed 2 count charges against the defendant. The charge is dated on the 19th day of November 2024 and filed on the 20th day of November 2024.
Mr. Ndanyi, please mute your device.
To be read to the understanding of the defendant.
There is a device that is on, that is really, okay. Go ahead, please. Affirm, read, translate, interpret the charge to the defendant.
You, Aliyu Alhaji Aliyu of 9 Hour Ward, Damaturu, Yobe State, on 18th day of November 2024, at the course of stop and search operations by NDLA officers along Damaturu Potiskum Road, Damaturu, Yobe State, within the jurisdiction of this honorable court, without lawful authority, you were found and arrested in possession of 10 kilograms of cough syrup with codeine, suspected to be psychotropic substance, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the National Drug Law Enforcement Agency Act, Cap 30, Laws of the Federation of Nigeria, 2004, as amended. Zai maka fasara ta. Cewa kai mai suna Aliyu Alhaji Aliyu, wanda ke angon Nainawa, nan jihar Damaturu, a rana ta 18 ga watan 11 na wannan shekara, yayin da masu hana sha da safara ta miyagun kwayoyi na kan aiki a hanyar Potescum zuwa Damaturu nan jihar Yobe, karkashin wannan hukunci na wannan kotu mai girma, ba tare da doka ta baka izini ba, an same ka da mallakar kilogram 10 na cough syrup wanda ke da codeine, wanda ke kama da cocaine da kuma heroin da LSD, wanda laifi ne wanda hukuncinsa na karkashin sashe na 19 na hukumar nan na masu hana sha da safara ta miyagun kwayoyi ta ƙasa 2004 wanda aka sabanta. Ka fahimta? Na fahimta.
Since you said you understand the charge read out to you, why are you pleading to say charge?
Tunda ka ce ka fahimta, ka aikata ko baka aikata?
Ban aikata ba.
Yes, my lord. The defendant pleaded not guilty to the first count charge.
Yes, read out the second charge in Hausa language.
All right. Cewa kai mai suna Aliyu Alhaji Aliyu wanda ke angon Nainawa nan jihar Damaturu karkashin a rana ta 18 ga watan 11 na wannan shekara yayin da masu hana sha da safara ta miyagun kwayoyi ta kasa na kan aiki a hanyar Potescum zuwa Damaturu nan jihar Yobe karkashin wannan hukunci na wannan kotu mai girma an same ka kana ɗauke da kilogram 10 na cough syrup wanda ke da codeine wanda ke kama da cocaine da heroin da kuma LSD wanda yin haka laifi ne wanda hukuncinsa na karkashin sashe 11 ba na hukumar nan na masu hana sha da safara ta miyagun kwayoyi ta kasa 2004 wanda aka saba ne.
He was found arrested transporting. I didn't hear you transporting 10. I didn't hear the transporting.
Yes, my lord. Tafiyar da. Ana tafiyar da.
Are you sure it's tafiyar da? Transport.
Transport.
Bilagoro.
Kana bilagoro. A ɗauka za ka yi tafiya da shi. Kana bilagoro na kilogram 10.
Do you understand the charge that read out to you? Since you understand the charge, how are you pleading to say charge?
Tunda ka ce ka fahimta, ka aikata ko baka?
Ban aikata ba.
Yes, my lord. The defendant pleaded not guilty to the second count charge.
Thank you, Mr. Ndahi.
Thank you, my lord.
Yes.
My lord, since the defendant has pleaded not guilty to the content of the charges, my lord, may I be asking for a jet, my lord, to produce witnesses in proving this matter?
Yes, my lord, before taking a date, pending bail application for this honorable court, my lord, subject to convenience of the court and that of my learned friends, I humbly apply to move the application, my lord.
Were you ready?
Go ahead then.
Yes, my lord, before you, dated 20th day of November 2024, sorry, my lord, and filed on 21st November 2024, my lord. My lord, the motion is brought forward to order. The motion is brought forward to section 158 to 165 of the Administration of Criminal Justice Act 2015 and section 35 of 4 and 36 of the 19th Constitution of the Federal Republic of Nigeria as amended and under the power jurisdiction of the honorable. My lord, the defendant did not file a counter. I humbly apply to move the application in terms of the motion paper.
You mean the prosecution? Yes.
Yes, attached to this application is 9-paragraph affidavit proposed by one Abdullahi Ibrahim Gambo, litigation secretary from the Anglo chambers. We rely on all the environment contained in the affidavit, my lord. And attached to this application, my lord, is Exhibit A, which is a charge sheet, copy of the charge sheet, my lord. And in compliance with the rules of the court, accompanied to this application, my lord, is a written address in support for motion for bail. I humbly apply to adopt same as our oral argument before the court, my lord. I humbly apply or urge my lord to grant our prayer contained in the application. May it please my lord.
This honorable court, having listened to the application for the bail of the applicant defendant, will deliver a ruling shortly.
As the court pleases, my lord.
Ruling.
Please.
The applicant defendant counsel applied for the bail of the applicant defendant and moved his application on terms. The prosecuting respondent counsel did not oppose the application. This honorable court, having listened to the application and adumberation of the learned counsel to the applicant, and after perusing the motion for bail with attached processes, hereby grants the application on the following conditions. One, a sum of 4 million naira and 2 sureties in the like sum. The first surety must be a traditional or religious leader in Yobe State. The second surety must be a responsible member of the society from any sector. 4, the 2 sureties to stand for the defendant must be resident in any of the local government capitals of Yobe State, and that fact must be verified by the NDLEA as reliable. 5, the 2 sureties shall each swear to an affidavit of means. 6, the defendant applicant together with both sureties must each deposit 2 copies of their recent passport photographs with the station registrar of this court. 7, the defense counsel shall write a formal letter to the station registrar, Federal High Court Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendant on bail pending his trial. 8, the defendant is to provide a valid active bank account attached to a BVN number. This fact must be verified by the defendant counsel as having been complied with for the release of the applicant on bail. The application on the terms and conditions as prescribed. Meanwhile, the defendant is to be remanded in Potiskum Correctional Center until he fulfills the bail conditions. Ms. Enda, give me a date.
We are very much grateful, my lord.
Okay. Ensure that the sureties you get eventually should not be elderly men who are in the evenings of their lives, and you stress them when, for any reason, the defendant doesn't come to court.
As the court pleases.
And one other thing that I wanted to remind, which I've forgotten before, maybe I'll remember before the end of proceedings. Give me a date, Mr. Ndahi.
Yes, my lord. 6th February 2025.
I think my lord want to suggest about the old age of the sureties, right? If I'm not mistaken.
Yes, I've stated about the age of the sureties. And I think what I wanted to add is that they should be informed of the enormity, of the seriousness of of being a surety. Yes, and then the defendant as well, you should inform him that if for any reason he doesn't appear in court, his bail will be, the word has escaped.
Revoked, my lord.
Revoked, yes. His bail will be revoked. Thank you. Did you say 6th February?
Yes, my lord.
Okay, thank you. This matter is hereby adjourned to the 6th day of February, 2025.
We are very much grateful, my lord.
You're most welcome.
Thank you. Na daga wannan zama sai ranar 6 ga watan 2 na shekara mai zuwa. Officer.
Please, can you call the next case?
Charge number FSC/DM/CR/46/2024 between the Federal Republic of Nigeria and Saleh Ali.
Yes, my lord. The defendant is present here at the correction center. And he speaks Hausa, my lord.
The presentation, please.
May it please my Lord, and B. Muhammad, PSC, for the complainant, my Lord.
Okay. Thank God, Council. One can hear you loud and clear.
Thank you, my Lord.
Any counsel for the defense, for the defendant? Any counsel for the defendant?
No counsel, my lord.
Okay. Yes.
My Lord, the matter was later today for mention, and my Lord, we have an application to make before mentioning the matter, my Lord.
Go ahead.
Thank you. My Lord, our charge was undated. We are applying before this court to date our charge, my Lord.
I didn't hear your submission.
Yes, my Lord, we are applying before this court to date our charge, my Lord. Because on the basis of our charge, it was not dated, my Lord. And we are applying before this court, my Lord, to date our charges, my Lord.
You have to complete your application. You apply for the date, everything, but I don't like this piecemeal submission.
Sorry, my Lord. Our application is, my Lord, we are applying to date our charges. Thank you, my Lord.
Date it when?
Yes, to dated the 7th day of October, 2024, my Lord.
You have a charge dated 7th October.
Yes, my Lord.
Yes. Application granted.
Thank you, my Lord. My Lord, before this honorable court is our charge formation, my Lord. And the charge was dated the 7th day of October and filed the 11th day of October, my Lord.
No, it's impossible. Okay. Which case, since October, you did not bring in the, since October?
Dated the 7th of October, my Lord, and filed the 11th of October, my Lord. And we applied for this charge to be read to the accused person to take his plea, my Lord. Thank you, my Lord.
This is the same matter that has been adjourned about 4 to 5 times. Okay.
Yes, my Lord.
Because since October, I'm surprised. Can you ask the defendant, because I realize that he doesn't have counsel.
Yes,
ask the defendant whether he needs time to engage counsel, or should we continue with the procedures? Mr. Salisu, can you hear me?
Yes, my lord, I hear you.
Ask the defendant if he requires the services of counsel, he needed time to engage counsel, or should we continue with the procedures as it is?
As God please, my lord. Kotu ta ce a tambaye ka ko kana da ra'ayin ɗaukar lauya da zai kare ka, ko kuma za a gudanar da shari'a ne haka. Ka faɗa sosai.
Ba da ƙarfin ɗaukar lauya, bisa ga yanzu haka ma jinyan da ake a cikin gida ban san yadda ake tafiya ba ga mahaifiyata.
Let him just answer answer the question. Does he require a lawyer, or does he want the matter to engage?
Ka ɗauki lauya ne ko kuma za a shari'a haka an sa kawai da haka.
Bayan da ƙarfin ɗaukar lauya.
He has not answered my question. Does he want the proceedings to continue?
Kana so a ci gaba da shari'ar haka ne za ka kare kanka ko kuma za ka ɗauki lauya ne mai kare ka? Ka bada ansa.
Kawai a taimaka min kawai a mun abu nan hukuncin da ya dace ba matsala ba sai na ɗauki lauya ba, a taimaka min.
Read out the charges to him.
As the court pleases. Zan karanta maka abin da ake tuhumar ka da shi. A turance yi maka fasara ta Hausa. That you, Saleh Ali, male, Sani Useni, male of Ngeljuli village, Gujuba local government area, Yobe State, on or about 8 May 2024 at about 1700 hours at Shamka village, Gujuba local government area, which is within the jurisdiction of this honorable court, committed an offense by doing an act which you were illegally found in possession of a gun. You thereby committed an offense of illegal possession of firearms punishable under section 28(1)(b)(3) and 28(1)(c)(v) respectively of the Firearms Act, Laws of the Federation of Nigeria 2004. Zan yi maka fasara ta Hausa. Cewar kai mai suna Saleh Ali namiji, an sake rubuta wani mai suna Sani Hussaini namiji wanda ke kauyen Ngeljuli a karamar hukumar Gujuba nan jihar Yobe a rana ta 8 na watan 5 na wannan shekara misalin karfe 5 a kauyen Shamka a karamar hukumar Gujuba ba tare da a karkashin wannan hukunci na wannan kotu mai girma ba tare da doka ta baka izini ba an same ka da mallakar bindiga, wanda yin haka laifi ne wanda hukuncinsa na karkashin sashe 28 layi na 1 da kuma B layi na 3 da kuma 28 layi na 1 ca da kuma V na hukumar nan na doka ta kasa 2004. Ka fahimta?
Do you understand the charge read out to you?
Ka fahimci abin da na karanta maka?
Ka fahimci abin da ya karanta?
Na fahimta.
Since you said you understand the charge, how are you pleading to say charge?
Tunda ka ce ka fahimta, ka aikata ko baka aikata ba?
Abin da yake tafiya ba ganganci ba wani abu, tabbas haka ne.
I can't hear you. Ban ji abin da ka faɗa ba.
Ka aikata ko baka aikata ba?
Tabbas haka ne ya faru.
Yes, the prosecution counsel. Yes, I heard him.
My Lord, as the defendant pleaded guilty, my Lord, we apply to review. We apply for a review of the facts, my Lord, and we are ordering the court to adjourn the matter and let us be guided by the court therein, my Lord. Thank you, my Lord.
6 February 2025. 06 February 2025.
Okay, thank you. My Lord, we suggest 6 February 2025, my Lord.
This matter is hereby adjourned to the 6th day of February 2025 for review of facts. Meanwhile, the defendant is to be remanded at the Potiskum Correctional Center till then.
As a copy, this.
Yes, my lord.
Thank you, my lord. As a copy, this.
Voting biyu. Kotu za ta ci gaba da zama. Ka je ka zauna.
Okay, is that it, or do we have other cases?
That is all.
Okay, yeah. Okay, Mr. Ndahi, you're muted.
Yes, that is all for the day, my lord.
Okay, thank you so much, Registry of Court, Mr. Sargis at the Correctional Center, thank you so much. Officials of the Potiskum Correctional Center, thank you. Really appreciate your assistance. Mr. Ibrahim, I can see you from afar. Thank you. All officers, thank you. Thank you so much as well, counsel that have appeared. I can see Mr. Bamala.
Thank you, my lord.
And all other counsel, Mr. Mohammed, everybody, thank you so much.
Thank you. Thank you very much, my lord. You are welcome.
Okay, have a blessed week ahead.
Thank you.
My lord, this is my colleague, Mr. Ibrahim Muhammad, my lord. He is a new prosecution counsel, my lord, here in Yobe State Command, my lord.
Okay, his name is Mr. Ibrahim?
Yes, ma'am. Yes, my lord.
Okay, Mr. Ibrahim, you're welcome to Damaturu, Yobe State. I'll be looking forward to see you appear in court. Mr. Bamala has done very well. I hope you'll follow in his footsteps or even go beyond what he's doing. But so far, so good. Thank you so much.
Thank you, my lord.
Okay, bye-bye then. Thank you, everybody.
Thank you.
I forgot to thank Fortune Technologies for assisting us with this, with the software and everything to enable us sit virtually most times. And today, thank God, we had a hitch-free proceedings. Thank you so much, everybody, Mr. Ndahi and the Madam Juma and everybody in court, as well, Mr. Sani, Mala Usman, Mr. Umar, everybody. Thank you so much, Federal High Court. Bye-bye then. Thank you.
Bye. Thank you.
Okay.